Hello everyone. Let us see the verdict of Bachan Singh case, in which our Supreme Court have decided the constitutional validity of the death sentence. Death sentence, which we also call it as the capital punishment, is the form of punishment. Rather, it is the gravest form of punishment, in which the accused is hanged by his neck till his death, to the contention of Bachan Singh, who had committed multiple murder, that it is constitutional invalid provision which provides for the death sentence. That is, he talks about section 302 of the IPC, which provides for the punishment for the offense of murder, and his contention was in this case that this section is constitutionally invalid because it takes the fundamental right of the person, and that to be specifically Article 14, Article 19 and Article 21 का violation है. So let us see what our Supreme Court have decided and what guideline Supreme Court have laid down regarding the rarest of the rare case, because in this very case Supreme Court ने बोला कि death sentence is all constitutional and it is only given in the rarest of the rare case, considering all factors, be it aggravating factor or the mitigating factor. So let us see detail of this case. So name of this case is Bachan Singh versus State of Punjab, whose judgment came on 9th May 1980, and the citation is 1980 Supreme Court, and the equivalent citation is 1982 Supreme Court or 1983 Supreme Court. It was decided by 5-judge bench, and the judgment came by 4:1 majority, in which Justice P.N. Bhagwati have dissented. Let us see who all were there in this 5-judge bench. It was Justice Y.V. Chandrachud, who was Chief Justice at that time. Along with him, Justice A.C. Gupta, Justice N.L. Untwalia, Justice P.N. Bhagwati and Justice R.S. Sarkaria was there, and this judgment was delivered by Sarkaria Justice. Let us see the background of this case. Bachan Singh was convicted for the offense of murder, and murder is one of the gravest offense under the Indian Penal Code. Now, so we have the Bharatiya Nyaya Sanghita, because IPC is no more applicable. So at that time IPC was applicable, and that to be section 302 provides for the punishment for the offense of murder, and in the punishment, death sentence, which we also call it as the capital sentence, is one of the form of punishment, along with the life imprisonment, which we also call it as the imprisonment for life, and fine. So section 302 के तहत बच्चन सिंह को convict किया गया था by the trial court, that was even upheld by the High Court of the Punjab and Haryana, and ultimately he appealed against the decision of the High Court in the Supreme Court, where Supreme Court have held that his conviction is all valid and death sentence is all constitutional, provided it is only given in the rarest of the rare case. So what happened that when he have appealed in the Supreme Court on the ground कि this section 302 is constitutionally invalid, and he took the ground कि imposing death sentence is arbitrary action and it violates Article 14, right to equality. It says that imposing death sentence will curtail all the freedom which is being provided under Article 19, and moreover, as a person is hanged by his neck till his death in the death sentence, so it is the violation of right to life and personal liberty as provided in Article 21 of the कॉन्स्टिट्यूशन। तो बच्चन सिंह का ये कंटेंशन था कि सेक्शन 302 of the IPC is constitutionally invalid provision because it violates fundamental right of the person, and moreover it is an arbitrary action to take the life of some person on the ground of punishment. But our Supreme Court have ultimately declared that death sentence is all constitutional because we have forms of punishment, and if we talk about IPC as provided in section 53 of the Indian Penal Code, which for brevity I'll be calling it as the IPC, we have 5 forms of punishment. The gravest form of punishment is the death sentence, that is hanging accused by his neck till his death, and then is the imprisonment for life. Imprisonment for life ko we also call it as the life imprisonment also. Imprisonment for life means till the whole of the remainder of the life of the accused he had to be inside the jail. And the third form of punishment is imprisonment for a term. And who will decide what term ka imprisonment will be imposed? It is the court itself. Seeing the nature of the offence and the nature of the offender, the severe the offence will be, the higher the punishment will be. Moreover, court ये भी ध्यान रखेगी कि क्या it is the first time offender, young offender, or it is being committed by the habitual offender. So imprisonment for a term, and this could be further classified into rigorous form of punishment. Rigorous form of punishment means with hard labor, and if it is without any hard labor, then it is the simple form of punishment. So imprisonment form for a term could be further classified into rigorous. Rigorous means with hard labor, or it could be simple form of imprisonment. Next form of punishment is the forfeiture of property. Forfeiture of property means confiscation of the property. And the fifth form of punishment under IPC is the fine, that is penalty in terms of money. And if we see our new law, that is Bharatiya Nyaya Sanhita, which for brevity I'll be calling it as the BNS, then under BNS we have 6 form of punishment. One new form of punishment has been added along with these 5, and that is the community service. So when we see section 4 of the Bharatiya Nyaya Sanhita, so one new form of punishment has been added along with the death sentence, जो पहले भी था, life imprisonment, imprisonment for a term, which could be rigorous or simple, or it could be forfeiture of property, or it could be the fine. And the new form of punishment is the community service. Community service matlab any kind of service which is for the benefit of the public, and the term community service has been provided in section 23 के explanation में, and that to be of Bharatiya Nagarik Suraksha Sanhita of 2023. So in both the law, be it the IPC or the BNS, death sentence is the form of punishment, and that could be awarded in the rarest of the rare case. And when the court is awarding death sentence, then in that situation all the circumstance of that case, be it the mitigating situation or the aggravating situation, that all will be taken into account. So let us see what legal provision was involved in this particular case. It was section 302 of the IPC. 302 of the IPC is the punishment clause for the offence of murder. It gives death sentence as the alternative form of punishment. Along with life imprisonment, which will be coupled with fine, we have death sentence as a form of punishment. Death sentence hai, and life imprisonment and fine. Along with section 302 of the IPC, section 354, subsection 3 of the Criminal Procedure Code of 1973 is being involved in this case, because this section talks about the contents of the judgment, and whenever a judgment in writ is there, and if death sentence is awarded in that very case, so special reasons will be recorded. So this section talks about special reasons to be provided if death sentence is imposed as a form of penalty, as a form of sentence to a person. And along with this, Article 14, Article 19 and Article 21 of the Constitution of India was involved, because this section talks about right to equality, right to freedom and right to life and personal liberty respectively. As we all know, under the new law, section 103 subsection 1 now talks about the punishment for the offence of murder, which was earlier given under section 302, and the punishment remains the same, death sentence. Along with that death sentence, life imprisonment and fine is there. So alternative sentence are there. That's why the court said that rarest of the rare case mein hi death sentence will be given. It is not the matter of rule only. So rule is life imprisonment and death sentence is the exception to it. That was laid down in this case itself. And section 354 subsection 3, which talks about the content of the verdict may, that is special reasons for awarding death sentence should be there, and this is now being provided in section 393 of the BNSS. Article 14 talks about right to equality, and the Bachan Singh claimed that his right to equality is being violated because imposing death sentence is an arbitrary action of the state. And Article 19 may, whatever freedom is there, that will be automatically curtailed if the sentence will be imposed according to him. And right to life will obviously be taken away if a person will be given capital punishment. So these are the legal provisions which was involved in this case, and the Supreme Court by 4:1 majority have decided this case that the conviction which was held by the trial court, which was again upheld by the High Court of the Punjab and Haryana, is all correct decision of these courts, and the provision of death sentence is all constitutionally valid. So death sentence as a form of alternative punishment as provided in section 302 of the Indian Penal Code is constitutionally valid provision. It is not violative of any of the fundamental right. So this provision, that is section 302 of the IPC, was held to be constitutionally valid provision through this case, and moreover the court have laid down the guidelines कि किस situation में death sentence will be imposed, and that was named as the rarest of the rare case. Only in the case of rarest of the rare, death sentence will be awarded, because rule is always the life imprisonment and death sentence will be its exception as laid down in this case. And all the circumstances, be it the aggravating factor, along with the aggravating factor, जो भी mitigating circumstances हैं, mitigating factor, that all will be taken into account while deciding death sentence as a form of punishment. This was being laid down, whereas it was dissented by Justice P.N. Bhagwati on the ground that it is arbitrary action. But we go by the majority decision, and that is true also. And this is the very case in which it was held that death sentence, which is the gravest form of punishment, which we also call it as the capital punishment, is all constitutionally valid sentence. It is constitutionally valid. It is not violative of any of the fundamental right, but it is only awarded in the rarest of the rare case, considering all the circumstance of that particular case, be it the aggravating factor or the mitigating factor. So this case stands a landmark judgment in the penal laws as well as in the constitutional law. It's also when it comes to deciding the sentence of a person. Now it's the time for your practice question. You have to tell in the MCQ question mein that which principle Supreme Court have established through the case of Bachan Singh versus State of Punjab regarding the imposition of death sentence. So you have to tell that out of these 4 options में से which is the correct one when it is there with respect to the principle as decided by the Supreme Court in Bachan Singh case with respect to the imposition of death sentence as a form of punishment. Is it the default punishment for the offense of murder? By the virtue की murder हो रहा है तो death sentence will be given to all of the accused whose guilt is proved beyond reasonable doubt, or it is the option that that sentence is unconstitutional in all the circumstances, or it is the option number C which says that death sentence is awarded and that to be only in the case of rarest of the rare case, or it is the last option D which says that it can be imposed without providing a special reason. So you have to tell which principle was laid down in the Bachan Singh case regarding imposition of death sentence as a form of punishment. Is it option number A which talks about default punishment, or is it option number B which says that death sentence is unconstitutional in all the circumstances, or it is C which says that it is constitutional provided it is given in the rarest of the rare case, or it talks about that whenever death sentence is imposed then special reasons is to be recorded that why death sentence is being chosen as a form of punishment to the which is given to the accused. Let us see what subjective question we have. You have to write that in this subjective question you have to critically analyze the rarest of the rare doctrine, that what guidelines was laid down by the Supreme Court, that how a case will be termed as rarest of the rare case, because if a case is rarest of the rare case then only death sentence could be awarded. So what principle were laid down through this case that you have to tell regarding rarest of the rare doctrine, and you have to tell that what impact it had on the criminal justice system, because ultimate object of the any law is to attain justice. If suppose there is any crime, how justice will be achieved? By awarding punishment to the wrongdoer. So how this rarest of the rare doctrine जो कि laid down किया गया था in the Bachan Singh case has impacted the criminal judicial system of India, and what challenges are there when we apply it, because on one side right to life is also involved. So how that balance is drawn when death sentence is awarded as a form of punishment, that you have to write in mains. Thank you.